Let's unpack this further now. Joined by Tumelo Machaba, candidate attorney at the Legal Resources Center. Tumelo, good to have you, and thank you very much for your time. Yet another delay in the matter when we're already looking at the matter saying it's 22 years later that it is actually happening. Firstly, why was the first indictment of the two only seen around 2021? And what does that say to this notion or this perception of a political directive to delay this matter so that it doesn't get to the courts?
Well, thank you. Good evening, and thank you for having me. Well, it is true that, there has been a delay in this matter, and it's quite unfortunate. It's much because the family are seeking justice and closure for their loved ones. But, the TRC played an integral role in this matter finally getting to court today. You would remember that the Cosas Four were made to believe that, it was made to believe that they actually blew themselves up. But it was only during TRC hearings that it actually came out that they had been assassinated. And so during TRC hearings, the accused in this matter obviously tried to apply for amnesty, and they were denied. And so the TRC referred these matters to SAPS as well as the NPA. And of course, there was a lot of political interference and a lot of postponement and challenges. And there are several case law in South Africa which prove this. We have Bengayimeng versus National Director of Public Prosecutions, where challenges such as these matters being pressured to be dropped, the TRC cases specifically were pressured to be dropped. So the matter being set down for today was a huge milestone, for our country, and it's really unfortunate that it was postponed to next year.
Yeah. What would you pin that to? Is it a lack of proper investigation, a lack of just tying up the loose ends?
Mm-hmm. Well, the spokesperson for the NPA has provided that the South African Litigation Center, SALC, brought in an application to be amicus in those proceedings. And the court decided that they will hear that on the 23rd of October, and that subsequently led to this trial being postponed to January. Unfortunately, for the family, that is not good news, but that was the decision of the court today.
How important is for SALC to be a part of this? To the point where the family would need to bear the fact that the matter will now be postponed to next year?
Well, it depends how one views the importance of amicus in matters in general. But the South African Litigation Center, are known for fighting for people's human rights. And there were discussions with the family to try and show them the importance of them being joined into the matter. Of course, they delay the trial, but as friends of the court, they also play an integral role, in providing or leading evidence. It depends on them in bringing their application, whether they'll be providing oral or written submissions. But their history of how they fought for human rights, different people, they could play a very integral role in this matter.
As far as the long wait is concerned, we know, for example, that the impact thereof is the fact that the kingpins, the masterminds behind this are really not the ones that are facing this particular trial. You've got, one, Rorich, who was a former security branch explosive expert, and a former Askari, Ephraim Mfalapitsa. And some would say if you look at Askaris and how they work, they could have, the state could have put pressure on them. They could have been intimidated to be informers of the state. How is that going to impact on the outcome?
Well, that will obviously be something that the defense would have to bring to court. That would be the defense of the accused. That would be the defense of Mfalapitsa to say that he was, forced to be an informer, whatever the case may be. So that is why there is a trial. That if he feels that that is his defense, then he needs to bring it to trial and put it before the court, and the court will decide, the outcome of that.
Yeah. Section 232 of the Constitution is really what is quite historic about this matter, where crimes against humanity are going to be tried in our courts. It's a state alleging an unlawful and intentional killing of someone in part because of the system, but a system which aims to eliminate your political opponent. So what are the key aspects of that particular approach to the case? What are the elements that would be critical to prove here?
So this case is very significant, and historical, mainly because of the charges that are brought. So yes, we have the charge of kidnapping and murder, but very importantly, you mentioned Section 232 of the Constitution. So that section says that customary international law is law in South Africa unless it is inconsistent with the Constitution or an act of Parliament. And that is the very basis in which why in this case we have charges of crime against humanity of apartheid and crimes against humanity of murder. So those are international law crimes, and they are brought as charges in this case. And, very interestingly, that will be the first time in South Africa that the crime against humanity of apartheid is brought in South Africa. And not only that, it will be the first time around the world that the crime against apartheid is actually in court.
And how difficult, or how easy would it be to try a case like that, especially with the kind of time lapse that has taken place?
Well, in terms of the time lapse, like you mentioned, the kingpins have passed away, and obviously the MPA is the one who has the mandate. They will be the one leading evidences to this matter. And secondly, in terms of proving these charges or whether or not they should be admitted into this case, these charges under international law, it would have to be proven that they have to be included in the indictment against the accused. So it is a huge task. It is the first time that we are facing this in our courts, and the NPA have a huge task in front of them.
So what could be the outcome of trying this using international law in terms of the appeals processes, but in also terms of the sanctions that will be meted out at a later stage?
Well, I cannot say what the outcome would be, but definitely, if justice does prevail in this matter, it will be a huge milestone in South Africa's jurisprudence there are many crimes, that have been committed. There are many amnesty applications that were denied in the TRC. There are many amnesty applications that were not brought forward. So there are many criminal cases which have not been brought to court. So if this were to be successful, that would be a huge milestone in our jurisprudence.
Yeah. I'm asking because, for example, if we speak about crimes against humanity, most of the times we see them being tried on the International Criminal Court. This one is going to be tried in a domestic court. If the trial progresses to that level, does that mean that options of appeal would even extend to the International Court?
Well, that would be really interesting. But, obviously, in this matter, if it was to be appealed, we have the Court, and possibly it could be taken up to the highest court, the ICC. But, it's even getting through this hurdle of it appearing in the High Court that we need to pass through first.
And what support then will you be bringing into this particular matter?
So the Legal Resources Center are the attorneys representing the families of the Cosas Four. And so that is the support that we're bringing in. We are the instructing attorneys. And we also have the NPA, obviously, who will be leading evidence in trying to prove the charges against the accused.
All right, fantastic. Tumelo, appreciate your time. Thank you very much for coming on and sharing this with us. Tumelo Machaba, candidate attorney, Legal Resources Center there.